When we last spoke, I informed you that the Menendez case has been on 3 parallel tracks. The first track was the habeas track. That was a track started with a motion filed in May of 2023, where the Menendez brothers are asking for a new trial based on new evidence. About several weeks ago, we filed our informal response dealing with that habeas petition, opposing the habeas petition and saying that the justification for the new trial based on 2 additional pieces of evidence did not meet the legal standard to warrant a new trial. The second track that the Menendez case is on is the clemency track. This is a petition that the Menendez brothers filed directly with Governor Gavin Newsom. He could have acted on this petition either now, he could have acted on any moment since he has been in power since 2019. He can act on it today if he so chooses. He has unilateral constitutional power to commute the Menendez's sentences if he chooses and release them today. There is no hearing he needs to have, there is no deadline, and he can also do nothing. The third track is resentencing, and we are here today to discuss that third track. The resentencing is a law that was passed by the state legislature in California, somewhat unique law to California, that basically gives the judge, under certain circumstances, the power to resentence someone who has been previously sentenced. In this example, potentially, the judge could resentence the Menendez brothers from life without the possibility of parole to life with the possibility of parole. Now, resentencing hearings get started in 2 different ways in this case. One of the ways is that the court has initiated these proceedings itself under Penal Code Section 1172.1A1. The second way it also got started is when the prior district attorney filed a motion under this code section to begin the resentencing proceedings. What the position we are taking today is that we will go forward. We are prepared to go forward with the court's initiated resentencing proceedings and look forward to a resentencing hearing on that motion. However, we are asking the court to withdraw the previous district attorney's motion for resentencing because we believe there are legitimate reasons and the interest of justice justifies that withdrawal. Now, when one deals with resentencing, one of the key hallmarks of resentencing is, do the defendants pose an unreasonable risk of danger to the community? One way to decide if they pose that risk is to understand if they have been rehabilitated. And one way to understand if they've been rehabilitated is, have they accepted and exhibited full insight into the crimes that they have committed and accepted complete responsibility for their criminal actions. Governor Newsom gave us a primer on how this actually works when he dealt with the Sirhan parole recommendation that had been made to him back in 2021. At that point, Sirhan, who was the assassin of Senator Robert F. Kennedy in the Ambassador Hotel back in 1968, had been up for parole hearings 16 times. For the first 15 times, the parole board denied parole. But on this 16th time in 2021, the parole board recommended a grant of parole to Governor Newsom. So he looked at the case and he actually issued a written decision. And in that decision, he analyzed the factors that were both in favor of parole, and there's an analogy to resentencing, and the ones that weren't. The ones that were in favor for parole was that at the time of that parole hearing recommendation, Sirhan was 77 years old. He had been in prison for 54 years. He was suffering from a diminished physical capacity. In his childhood background, he had lived through a war-torn area. He was 24 at the time that he committed those crimes. And while in prison for those 54 years, he had engaged in comprehensive involvement in rehabilitative and self-improvement programs. He earned his Associate of Arts degrees and other certificates. He engaged, his classification score which is an analysis by the California Department of Corrections and Rehabilitation as to what type of risk level you're at, was at the lowest. It was a 19. In fact, the California Static Risk Assessment said it was that lowest level. His rule violation reports, that's the number of reports that he had experienced since he had been in prison since 1968, was 2. And the last one was in 1972. He had letters of support from prison officials, and he had letters of support from 3 of the 9 living Kennedy family members. Yet the governor looked at all those positive factors, recommending parole for Sirhan Sirhan. Now it's in 2021, 2022. But he said that one factor overcame all those other factors. And that one factor is that Sirhan Sirhan had not demonstrated full insight into his crimes. He had not completely accepted responsibility for his actions based on his multiple stories of what had occurred that night in 1968. So notwithstanding the fact that he did not, he had all these positive aspects, and he had the parole board recommending a grant of parole, in January 12, 2022, the governor wrote that Sirhan Sirhan poses an unreasonable risk of danger to the community and denied that parole. The reason this can be an instructive case is that there are almost no cases right now on Penal Code Section 1172.1, the resentencing statute. But the focus of it is the same focus as we have in the parole context. Is there an unreasonable risk of danger to the community by these particular people? In Sirhan Sirhan, he was a murderer of Senator Robert F. Kennedy, and he shot 5 additional people that night. And here we have the Menendez brothers, who are murderers of their parents the night of August 20th, 1989. While Sirhan Sirhan is 77 at the time that Governor Newsom made his decision, right now the Menendezes are either 57-year-old for Lyle Menendez or 54-year-old for Eric Menendez. They've served 35 years in prison. Sirhan Sirhan served 54 years. They don't suffer from the diminished physical capacity that Sirhan Sirhan does. They had also childhood allegations of physical, sexual, and emotional abuse in their childhood, while Sirhan Sirhan had never been arrested or charged or convicted of any crimes before his offense. Eric Menendez had been arrested for multiple residential burglaries and received diversion. And Lyle Menendez had also been arrested for multiple residential burglaries. When it comes to rehabilitative programs, yes, both Sirhan Sirhan engaged over the 54 years in significant programs, as have the Menendezes. When it comes to education that they earned, Sirhan Sirhan earned an Associate of Arts degree. Eric Menendez has earned multiple Associate of Art degrees and is currently enrolled in UC Irvine. And Lyle Menendez earned his Bachelor of Arts degree from UC Irvine. As far as classification scores, they're all at the same level, a 19, which is considered the lowest level you can be at in the prison system. With respect to that California Static Risk Assessment, they're all at the lowest level. Rules violations, you had 2. For Sirhan Sirhan, the last one in 1972. You have 9 for Eric Menendez, the last in 2021, and 8 for Lyle Menendez, the last in 2024. They each have letters of support from prison officials, and the Menendezes have multiple letters from all living victim family members aside from one who recently passed, and they received those letters in support of their being released.